Hi, I'm Linda DeBruin. I specialize in handling intellectual property matters. More and more these days, we are seeing multinational intellectual property matters. Cases filed not just in 1 or 2 countries, but 4 or 5 or more countries. Now, just as people may speak different languages in different countries, or drive on the left-hand side of the road instead of the right-hand side, the legal systems and practices for handling intellectual property disputes differ greatly from country to country. You can take advantage of that in handling your matters. Let's look at an example of a global intellectual property matter. I handled a case for a client, a patent infringement matter, that had been filed in the Eastern District of Texas against my client. Now, at the time, the Eastern District of Texas was not a friendly place for a defendant in a patent case. It was very pro-patent owner. Also, the company that had filed the case against my client had just won a lawsuit against another company on those same patents. To make matters worse, the Eastern District of Texas was a rocket docket, meaning that cases moved from being filed to being tried very quickly. So there we were, defendants in a pro-patent owner forum, trying to get up to speed very quickly on patents and issues that our opponent had been dealing with for years. Now, why am I telling you this when I'm supposed to be talking about global intellectual property matters? Well, the case didn't stop with the Eastern District of Texas. Instead, my client put together a team of lawyers from various countries and mapped together a strategy that used the differences in legal systems and practices between the various countries. For example, in the Eastern District of Texas, we were looking at a trial by a jury. In the United States, a jury typically hears the issue of infringement and patent invalidity and other defenses. There is no jury in other jurisdictions, such as Canada or the UK. My client filed an action in the UK asserting that patents related to the patents at issue in Texas were invalid. Now, that action was heard not by a jury, but by a judge in London. My client and its London counsel successfully proved that the patent claims, for the most part, were invalid. We never got to trial in the Eastern District of Texas, but if we had, a Texas jury may have come to a quite different result than that London judge. Let's look at Germany. Now, in Germany, the issues of infringement and invalidity of a patent in a patent infringement case are often bifurcated or split. They are tried to different courts on different schedules. Frequently, the issue of whether the patent is infringed is tried before the issue of whether the patent is invalid. This provides a great advantage to a company asserting a, let's just say, shaky patent, in other words, a patent of questionable validity, because they can move forward with an early infringement action and may end up forcing the defendant to settle, even though the defendant believes they could win an invalidity challenge. The defendant just can't afford to wait and have a finding of patent infringement hanging over its head while it pursues the challenge to the validity of the patent. Now, all of these differences are not written down in the law books. For example, I mentioned the Eastern District of Texas being pro-patent owner. I've also been in jurisdictions where there's a perceived bias against a foreign company coming in and asserting its intellectual property rights. That's something you want to know before you file suit in that jurisdiction, so that you can either avoid filing suit there and file somewhere else, or take steps to avoid any potential bias. So to sum up, just keep in mind one thing. There is no one-size-fits-all countries approach to handling global intellectual property disputes.